Well, hello, welcome. Employment Law Show back once again. John Scholes beside me, of course, co-host Lior Samfiru, co-founding partner Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. You can check that out anytime you would like. You can also reach Lior and his team anytime you like when we're not doing the show. How do you do it? 1-855-821-5900, the phone number. Email help@employmentlawyer.ca. But better still, there's a website that's free and anonymous called pocketemploymentlawyer.ca. Wrapped up into that, we talk about this all the time because we're really proud of it, Lior. It's been years since you started this, the Severance Pay Calculator. It used to be severancepaycalculator.com, but now it's wrapped into Pocket Employment Lawyer. 2 million people, over 2 million people have used the Severance Pay Calculator to have their eyes opened up about the severance they are actually owed. We'll get into that and use that a little later on the show. But this week, key questions about employment rights for older workers. That's a subject we don't often take care of, so we're going to do it on the next 30 minutes or so stay tuned for that. But we always start off with the week that was. My brother, what's going on your end?
A lot of questions answered always. You know, just before I get on here to do this show, I answer questions and feverishly trying to take a break to film this show, and then I'm right back at it. And that's why I like doing what I do. Every day is something different, a different question, a different issue, someone else to speak to. And that's why I like doing this show, because we can get a lot of people here and solve their workplace problems. I promise you, if you're dealing with a workplace issue, a boss, a bad boss, losing your job, changes to your job, changes to your pay, maybe you're being bullied or harassed, whatever that issue, there are solutions, there are options, there are legal rights that you have. And on this show, we cover as many of these as possible so that you can be armed with that knowledge. Now, if we talk about something here and it's not exactly your situation, you want to talk specifically about what's going on with you, that's very easy to do. You can always reach out to me at the office by phone or by email. We'll give you that contact information several times throughout this show today, so stay tuned for that. But I want you to always remember, you're not alone with your workplace issues. There are answers, and then there's legal solutions, and there's ways that we can deal with that problem to help you solve it, whether it's a vaccine issue, whether it's a severance issue, whether it's a temporary layoff, whatever the issue, yes, there's solutions. And to give you an example of exactly how the law operates, let me talk about a case that came across my desk just over the past few days. I spoke with a gentleman that, like many people, has been working regular Monday to Friday, kind of 9 to 5 type of a shift. Well, recently his employer came to him and said that because of a restructuring, that employee is going to need to also work every other Saturday. And that would be starting very soon. Well, for obvious reasons, that employee didn't want to work on a Saturday. He had family responsibilities and commitments, and he thought that his regular schedule, which he's been doing for over 6 years, was exactly all he needed to do. So he told his boss, no, I'm not going to come in on this Saturday. I'm home with my family. Boss says to him, well, we're still expecting you on Saturday. You have no choice. He doesn't come in on the Saturday, so he then gets contacted by his employer, who says, well, we consider that as a resignation. You had a shift. You didn't come into your shift. You've resigned. We're going to send you by courier your record of employment saying that you've resigned and wish you all the best in the future. Of course, this person, very upset by it, who wouldn't be, and he calls me. He calls me on that Monday and he says, did I do the right thing? Did I do something wrong? Did I, in fact, resign? All I wanted to do is continue working my regular shift that I've been doing for 6 years. So, John, of course, it's not a resignation. He did not resign. His employer decided to unilaterally change the terms of employment and then fire him because he didn't agree to accept that change. He had no responsibility or no obligation to accept that change. His employer did not have a right to impose that Saturday shift. And when this employee didn't come in, he was not resigned. He hadn't resigned. He was terminated. He was let go. And the law considers this to be a termination without cause, meaning he is owed severance. For him, that could easily be as much as 9 months pay, months, not weeks. But I wanted to bring this up here because obviously there's important lessons to everyone here. Ultimately, your employer cannot make significant changes to the terms of employment. Now, if this employer said, we're going to keep you Monday to Friday, but instead of 9 to 5, you're going to do 8:30 to 4:30, yeah, that's probably something the employer could have done. But to say you also have to work on a Saturday, no, they can't do that. That's a change that's above and beyond what an employer can do. And his refusal was not a resignation. It was a termination. And yeah, he's owed significant amount of severance.
Yeah, it's interesting because you mentioned, above and beyond what they can do. And I was wondering about that. So if he works, 5 days a week and every 2 weeks he works one extra day, to you and I, even though it's a Saturday, to you and I, it doesn't seem like that much more. I mean, it's a bit of a pain in the butt. He doesn't want to do it. But where is the threshold as far as what the employer can do? Half a Saturday, no Saturdays? I mean, obviously in this case, they weren't allowed to do it, but it seems like borderline, no?
Well, anytime your employer gives you another day of work, that's going to be a significant change. It's not just changing your hours a bit. It's not changing when you come in and when you go. It's another day, especially on the weekend, which of course is a big deal. To go from not working weekends to working weekends, it's a big deal. Now, every case is different, right? Not every situation is the same. For example, if he used to work every third Saturday and now his employer wanted to say you have to work every second Saturday, yeah, his employer may be able to get away with that. But to go from nothing at all to working every other Saturday, it's a big deal. So if you want to know if your change, the change that you're facing in the workplace, is a quote-unquote big deal, if it's a change that your employer is allowed to make or not allowed, let's talk. Give me a call, send me an email, and we can discuss it specifically.
Is this another one of those cases where, I mean, upon reflection or even before he said, no, I don't want to do it, he could have said, you know what, maybe I'll give it a shot. It gets me out of house working to Saturday. If I can just go to work for the day, that might be good every 2 weeks, right? And could he say that to his employer, saying, you know what, I'm not really a big fan of it, but I do like working for you. You're a good egg. We'll give it a shot.
He absolutely could have done that. He absolutely could have said, listen, I don't know how that's going to work. I don't know how I'm going to manage my family responsibilities, but I'm willing to try it. So employer, I'm going to try it for the next few weeks, see how it goes. If he had said that and said that in writing, yeah, he could have taken it out and tried it for a bit and seen over a few weeks how he felt about it. And if he still didn't like it, he could have said, no, that's a constructive dismissal. But he didn't do that. He didn't have to. In this situation, his employer is the one that chose to pull the trigger. He's been terminated. And of course, now he has to get paid severance.
As Lior mentioned, reaching out anytime, 1-855-821-5900, help at employmentlawyer.ca. If you just go to employmentlawyer.ca, that'll take you to the firm website. And under the media tab, you will find links to our radio show, which we've been doing probably for a decade at least now. Great stuff on the radio show. You can tune in across the country, find a station near you, call in, as a matter of fact, and ask some questions. Lior, I want to get to the first phone call from one of the radio shows now, and we'll talk a little bit about it.
My friend, he's worked 18 years with this company. The last year or half a year, he's worked from home lots, and then it got slow. Now they telling him time to go, and you only get 8 weeks severance.
Approximately how old is your friend, and what kind of a job was he doing?
He was surveying out-of-town lots. He's about 60.
Well, John, his employer is allowed to make that change, whether things are slowing down or they want to restructure, they want to do something else. They're allowed to part ways with this guy, even though obviously he's been there for a long time. Clearly he's good at what he does, or he wouldn't have made it through 18 years. They're allowed to do that. The question is not so much why they're doing it or can they do it. The real question is, what is he owed as a result of now losing his job after 18 years? Now, according to what we just heard, he was offered 8 weeks pay after 18 years. Well, clearly something is wrong there, and I hope our regular viewers understand now, and they know what I'm about to say. And what I'm about to say is that 8 weeks is not even close. This is a wrongful dismissal. He was wrongfully dismissed because he was let go after 18 weeks and only offered 8 weeks severance. Not even close. How much should it have been? How much would he have been owed for this to be a legal termination, not a wrongful dismissal? Well, rather than me just tell you right away, let's actually take this information that we have and let's go to our severance calculator so you can see how it's done as well. So we're going to go to pocketemploymentlawyer.ca. We're going to input the information into the severance calculator and let's see what we get. So this person we know is a lot surveyor. He's been there for 18 years, 60 years old, was offered 8 weeks severance. You see on the screen there that a proper severance amount for him is somewhere between 16 to 18 months pay. You can imagine if the guy was making $70,000, that's a difference of close to $90,000. That's how much severance he's been underpaid. By the way, you can do the same thing with your situation. If you've been let go, if you're worried about being let go and you want to know how much you are owed, not what the company says you are, what they want to pay you, how much the law says you should be getting, just go to pocketemploymentlawyer.ca and use our severance calculator tool.
You know, this one's really interesting too because, you know, like it or not, that difference, the delta, as you like to say, between 9 weeks and the 18 months, that is huge. And for a guy who's 60, again, like it or not, that's going to be tough for him to find a gig. I mean, I know people who are 45 and 50 who are competing with 25-year-olds, never mind a guy who's 60. So he's going to need that extra money to get him through while he looks for employment. Hence why it's so important to reach out, right?
And we'll talk about this more a bit later on the show when we talk about older employees. But for sure, the law understands that an older employee may take a bit more time to find a job than a younger employee. Right or wrong, that's what the law assumes. That's why older employees often get more severance, and that's the same for him as well. That severance is intended to carry him until he finds another job. So if it takes him 18 months to find another job and he only got paid for 8 weeks, you understand how big a problem that is. How does he pay his bill? How does he pay his mortgage or his rent? Huge, huge issue. That's why under no circumstances should he or anyone accept that severance offer before speaking to us, before we make sure that what he's been offered is the right amount.
You have questions any other time. You don't have to wait till this show is over. You can go to terminationquestions.com and ask them. We take some of them, actually, we read them out, and we talk about them here on the show. Lior, first one for today comes from Terrence. Says, at the start of the pandemic, our office shifted to a work-from-home model. Our boss sent an email a few months later informing staff that we would be working remotely on a permanent basis, even after COVID-19 ends. Last week, she decided to reverse her decision, saying we must return next week. Can she do that?
It's an interesting scenario. Now, if her boss said, just so you know, from now on, you're working from home, COVID or no COVID, you're a working from home employee. And then later on changes her mind, no, the boss cannot do that. If the boss does that, that's a constructive dismissal, meaning then that person is owed severance even though they are the ones refusing to come into work. So your employer can't decide to change something that you've been relying on. On the other hand, if the boss didn't say that and it was kind of understood that you're only working from home during COVID, then yes, your boss at that point can tell you to come back to work. And in that situation, if you don't come back to work, that's considered a resignation, right? You lose your job without any compensation. So the difference here is, was it understood that you're only working from home during COVID, or was it understood that you're going to continue working from home even beyond COVID? If it's the second scenario, if your boss now says to come back, you don't have to. And ultimately, if you lose your job, you're going to be owed your full severance.
Short break now, and coming up, as Lior mentioned, key questions on employment rights for older employees. So stick around for that. In the meantime, that number again, 1-855-821-5900 and help@employmentlawyer.ca. We'll continue. This is the Employment Law Show. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thank you so much for sticking around. Employment Law Show. Lior Samfiru there, of course, and John Scholes. You want to reach out, 1-855-821-5900 and anytime help@employmentlawyer.ca. I want to get into the topic of today, Lior. Old guys like us, we're starting to make up the majority of the workforce, and this is really important stuff. Key questions about employment rights for older employees. Yes, I included you with me. Sorry, pal. No gray, but come on, we're not kidding anybody. But this is really important for the aging workforce. The first question is this. Maybe not obvious, you might know the answer to this, but you may have old information, and that is, can an employer fire someone due to their age? Can it be let go because of their age?
I can't believe you called me old on TV, John. So John Scholes used to have a job. So we'll
That's right. No severance.
No severance whatsoever. Well, thank you for that, John. I appreciate that very, very much. But in all seriousness, we do have an aging workforce, and we do have employees now that are in their 60s and beyond, and we need to understand, and they need to understand what their rights are. And these rights, by the way, we're talking about older employees, but you'll see how those situations apply even in other scenarios. So with respect to older employees, we used to have in this province, in this country, mandatory retirement. For the most part, that's been gone for at least 15 years now. With mandatory retirement, what could have happened is employers were able to have employees or make employees resign at the age of 65. That's gone now. So an employer cannot let an employee go because of their age, whether it's 65, 85, or whatever the age is. That's illegal. An employee can choose to work as long as he or she wants to. Anytime an employer lets an employee go because of their age, well, that could be a human rights violation. You cannot let, that even can't be a consideration, John. Even if it's one of 5 considerations, it's still illegal. So you cannot be let go because of your age. You cannot be refused a promotion because of your age. You cannot be mistreated in any way because of your age. And if you are, that's a very serious human rights violation.
If you have these older employees, and I mean, they still love their job, they're doing the best they can, but maybe because of age, there's some performance issues starting to creep up. Can they be disciplined by the employer?
So the key here for an older employee that knows that their performance is going to be affected is to let the employer know, and ideally even provide something from a doctor confirming that. Because the employer may simply assume that, well, the performance issue is because you're not working hard, you're not trying. They may not understand that it could be a health issue or an age issue. So in that point, the employer may say, well, I had no idea. I disciplined you because I thought it was appropriate. So no, you can't be disciplined because your performance is suffering because of your age. But your employer needs to know about that. Now, of course, that doesn't mean that an employer should just accept bad performance, but there's ways for employers and employees to work together to ensure that those issues are covered. Maybe the employee gets additional support or help. But the key here is, as much as you may be uncomfortable, if you're that older employee and you don't want to necessarily admit to your employer that your performance is suffering, if you don't say something, that's when you can compromise your rights, because your employer may decide to let you go not knowing that there's a health or an age issue here. So it's as uncomfortable as it may be. Honesty is the best policy. If you're an employee, you know your performance is impacted, you can't do your job exactly the way you used to, be honest and open with your employer, and that's when the law comes and protects you.
Again, if you're just joining us, talking about key questions about employment rights for older employees, and if you are under this umbrella of an older employee, you're starting to fall behind a bit, maybe having some issues, can you and should you reach out to get some assistance, some aid, some skills training possibly to brush up?
So certainly, if you need some additional help, support, and oftentimes, you know, it may be other accommodation that you need to be able to do the job. You not only can you get it, you should get it. It's your employer's legal obligation to provide it. But as I said before, it's not enough. You can't assume that your employer is going to know that you need that. And it may not be enough for you to say, I want this or I need this. Ideally, you want to have something either that you provide your employer, even from a doctor if there's a health-related issue here. Ultimately, your employer does have that legal duty to accommodate you, and that means providing support that you need to be able to do your job. Like, your employer can't say, well, that's your problem, you figure it out. No, your employer has to be an active participant in the accommodation. And if your employer doesn't do that, again, that's a human rights violation. That gives you rights. They may have to pay you damages. It could be a constructive dismissal, you name it. So again, going back to what I said before, honesty is the best policy. If you know you need some support, tell your employer.
I know you've talked about the story anecdotally before, and aging employee, and the employer starts leaving golf brochures and timeshare brochures. If you weren't here, you could really enjoy your retirement. Can an employer, and should they be pressuring an employee to to pack it in and resign?
Yeah, that was an absolutely true story where the employer knew that it couldn't fire the employee because of their age, so it was dropping hints. Here's this brochure, here's some ideas. Why do you want to be here with all these young kids here? You want to enjoy your retirement. So, but that makes it uncomfortable, right? If you are feeling kind of excluded, you're feeling you're not wanted there, you're feeling that people think you're owed and not doing a good job. And just by pressuring that employee and putting them in that situation, that could be a human rights violation and a constructive dismissal. Your employer should not put any pressure on you to resign, not try to convince you to resign. Now, if they do, again, that's illegal. What an employer can do is find out what your plans are. Employee, I just wanted to know if you are planning on resigning or retiring at any point so that I can make arrangements. I don't want to be left, out in the cold. That's okay. And if your answer is I have no plans or I don't know, that's fine. They can't be follow-up. They can't be bugging you and consistently approaching you about this. So anytime you feel that you are mistreated because of your age, even if it's just pressure to resign, we need to talk because that's illegal.
How does the severance matrix work for older employees, by the way?
So we touched on that earlier. One of the three main factors that go into assessing severance is a person's age. The other two, by the way, is the length of your employment and the type of job that you have. And the reason we care about age is because older employees get more severance than younger employees, all things being equal. The law assumes that it may take you longer to find another job. So if you've been there for 10 years and you're 65, you're going to get more severance than if you were there for 10 years and you're 35. Okay, it could be significantly more severance. So that's why it's even more important for older employees to get that severance package reviewed, because what may have been appropriate for a younger employee may not be appropriate for you. And when we talked about our pocket employment lawyer and the severance calculator tool, it does analyze and consider your age in assessing how much severance you're owed. So remember the general rule, the older you are, the more severance you get.
Again, anytime you have questions after we cover one of these main topics on the show, you're like, I wish I could ask him something. Don't hesitate to do so. Lior and his team, they're right there and ready to serve you and answer your questions. 1-855-821-5900, help@employmentlawyer.ca. And as I mentioned, the radio show across the country, employmentlawyer.ca, the website. You can search out a station near you to catch that. It's an hour-long show. It's a beauty, and we tune into it every week. You can as well. We love doing it, and we get a lot of phone calls on the show. People have questions. They want to know stuff, and we'll get to our second phone call, Lior, from one of our radio shows coming up right now.
I was laid off. I worked for a hotel. Until August of last year, I was under the CEWS program, so I was getting paid by my employer. But since August, I'm on EI now. The hotel is fully opened. They haven't called me back, and my EI will soon run out. And they haven't given me a severance. So am I still employed or?
Mm-hmm. And I've seen this often at hotels, with restaurants. So at some point, your business may have been required to shut down by the government. In that time, when the business couldn't be open, even if they wanted to, if you're on a layoff, there's not much that you can do because it's not your employer's choice. They don't have the ability to have you work because the government says shut down. But once that changes, once the business is allowed to be back open, if your employer doesn't call you back to work, doesn't bring you back, then at that point, you, the employee, can choose to say, that's a termination of my employment. So this person works at a hotel. At some point, yes, the hotel shut down. But once the hotel reopened, because she wasn't called back to work, now she has two choices. She can continue sitting at home and seeing what happens, and maybe one day she gets called back. That's her decision. Doesn't sound like a very good option to me. The second option, I think the one that makes more sense, is to say, wait a second, employer. By not calling me back to work, you've terminated my employment. Again, constructive dismissal. Now you have to pay me severance. Mm-hmm. So she has that option. I don't know how long she worked there, but if she could get as much as 2 years severance if she's been there a long time. Same with you at home. If you're still on a layoff, waiting for your employer to call you back to work, yes, you can continue working. Can't tell you how much you're going to work, how much you're going to continue waiting. You can wait, for the next 10 years if that's how long your employer wants to keep you on. Or you can say, forget that. I am making the decision to treat this as a termination and get severance. You can do that right now. If that's what you want to do, let's talk about that. If you're not back at work, you're owed severance.
Love these phone calls on the radio show, Lior. I want to get to one more, but we got to do it on the other side of a break, which we'll take now. But the number as we get into a break, reaching out for Lior and his team, 1-855-821-5900, right? help@employmentlawyer.ca. We'll continue more employment law shows just ahead. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. A few minutes to go here, Employment Law Show. Good to have you along again this week. John Scholes beside me, of course, Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP. They are the most positively reviewed law firm across this country. How about that? Radio shows across the country. You played a couple phone calls from them, Lior. Let's get to phone call number 3 right now.
My daughter's going through this. She's been there 15 years. Unfortunately, for no fault of her own, the last couple of years she's been off on a LTD. They're saying that we want the latest updated medical from you. If your medical comes back and says, doesn't look like you'll be returning to work for a while, they will fire you immediately. They've already laid out their severance. They're only offering 1 week per year, and they're offering 15 weeks.
Big bowl of wrong.
It is a big bowl of wrong, and there's a number of things we need to kind of process here. So let's start, before we even talk about severance, let's talk about the fact that this employer is saying to her, hey, unless you're cleared to come back to work, then we're going to fire you. Can't do that, okay? You cannot let an employee go because they're sick, because they're disabled, because they're taking a disability leave, even if that disability leave is long. You can't. That's illegal. Human rights violation, potentially violation of the Employment Standards Act, wrongful dismissal, you name it, they've done it, it's wrong. The only time they could terminate in those circumstances is, number one, if the person's been off for a very long time. Let's call it 2 or more years, 2 years or more. That number one. And number two, if there's still no likelihood of ever coming back to work. If in those limited circumstances, very long absence and not likely to ever come back to work, then you can let go and only pay a week per year of service. Doesn't sound like that's what it is, because it's one thing to say, I can't come back now. Let's find out what happens in the future. So because of that, this is, again, wrongful dismissal, you name it, it's wrong. Even without that, 15 years of service, 15 weeks of severance, is that appropriate? Some people may think, hey, it's a week per year, that's the right amount. Not even close. Even if we forget the human rights issues, the discrimination issues, the disability issues, and we just focus on severance for a 15-year employee, she's owed a heck of a lot more than 15 weeks. So let's go to our severance calculator tool at pocketemploymentlawyer.ca. Let's plug the information in and see what she's actually owed. So 15 years of service, communications manager, I don't know how old she is. Let's say she's 45 years old, was offered 15-week severance. You see on the screen, she is owed as much as 8. That can easily be up to 6 figures that she's owed. So that's why it's important to get that advice. There's severance issues. There's human rights issues here. There's discrimination. You name it. What this company did is wrong, and she's owed significant amounts, John.
And the crux of this whole thing is that your doctors, your medical team are the gatekeepers of your health, and what they say, if you can't go back to work, you can't go back to work. It's their say, right?
You need the doctor's note. The doctor tells you and your employer if you can work, when you can come back to work, how long you're going to need to be off, what accommodation you may need. It all comes from that doctor. If you have that doctor's note, you are protected and your employer can't do anything to you.
That's why they always say you got to reach out to you guys whenever there's this problem. And on the other side, if it's a disability issue, you cover that as well at the firm, Lior. We talk about that on the Disability Law Show, which we cover as well. That's coming up shortly. But in the meantime, you need to reach out now that we are pretty much done for another show. Here is how you do it. One more time, 1-855-821-5900, the phone number, help@employmentlawyer.ca. That's the email we always use. And if you want to catch our TV show and the radio show, of course, you want to go to employmentlawyer.ca. Radio shows across the country you can take advantage of. Thank you so much for joining us, and we'll catch you next time right here on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.